But in this matter, I pray for a short accommodation.
Short.
My lord. There is much, nothing much is there, my lord. Just
ಇಲ್ಲ, ಇದರಲ್ಲಿ I pray-
PTCL.
I pray for a short accommodation. Mr. Jaykumar Patil is on his legs in the other court. Mr. Jaykumar Patil is on his legs on the other court. Short accommodation.
Eighth of.
After 45 years, they file a resumption application. My lord. After sale of 45 years.
He wants 8th of April. But on that day, Mr. Counsel. 8th at 2:30.
Lord, in this case, I refer the appellants, my lord. Appellants, my lord. My lord, appellants are the resident of apartment consisting of around 12 blocks and 1,200 apartments, my lord. My lord, out of which 350 apartments consist of large and small balconies, my lord. My lord, since the my lord, blocks are high-rise blocks, my lord, the few residents, that is the appellants, and also around 350 apartment owners have covered their balcony with temporary structures, my lord, just to avoid the falling from the top of the floors, my lord. My lord, one of the resident, since my lord, these 3 or 4 appellants had filed a molestation case against one of the resident, my lord, has lodged complaint before the BBMP as well as BDA, my lord, asking to my lord to remove this unauthorized construction. My lord, thereafter notice was issued, reply was granted. And subsequently, my lord, the commissioner has confirmed that order. And my respectful submission in these appeal is, my lord, the Bangalore Development Authority has got no jurisdiction to issue notice. Since my lord, the property comes from the jurisdiction of Bangalore Mahanagara Palike. However, my lord, that is subject, my lord, before the learned single judge. In the meantime, my lord, the impugn order, which is at Annexure 13, if my lords permit me to read, may I read, my lord?
Authority to challenge here, this interim order. It is not special. What will have to? Is there any direction to remove?
Please, my lord.
Where is it?
I'll just read, my lord. Ink page 13, my lord. Ink page 13 of the appeal, my lord. My lord, or to be precise, my lord, ink page 14, third paragraph, my lord. 2 weeks' time is granted to the petitioners to remove the structures in terms of the inquiry report submitted by the officers of the respondent BBMP. Lord, this is also because the report was submitted by BBMP with respect to connected writ petition, wherein only one notice was issued to one of the petitioner, which is where, my lord, the appellant 8 herein, my lord. With respect to other appellants, BBMP has not issued any notice. Now, subsequent to, my lord, order passed by the learned single judge, BBMP straight away comes, pasted a notice, my lord.
What is this structure?
No, temporary structure, my lord, covered with a temporary roof, my lord.
That
No RCC, no cement.
galleries are covered. Galleries are covered.
Balcony has been covered.
Balcony.
Small portion, my lord. And in fact, they have a larger portion also. But I have few photographs. If my lordship permit me, I can produce it, my lord. Very small portion, my lord. They have huge balconies only for the safety reason, my lord. And only these 11 appellants are targeted, my lord. There are 350 in the same complex, my lord. Lord, only because a criminal complaint was filed by three of the appellant herein, my lord, against one of the resident. They have been targeted, my lord. Lord, there are around 350 such balconies.
But this, if you are only putting up a roof on the balcony,
Please, my lord, roof and the cover.
how it can be said to be deviation from sanctioned plan?
Please, my lord. In fact, they have covered some appellants, my lord, they have covered. There are under 350 apartments, my lord. In fact, my lord, I have produced around five.
Even if they are temporary.
In fact, my lord, I had produced around 100+ photographs in and around Bangalore, my lord, where such owners have covered, my lord. But only these 11 appellants were targeted because of a criminal complaint filed against one of the residents, my lord. Because such complaint was filed for molestation, my lord, that accused, my lord, goes on filing before, in fact, all the authorities on the very same cause of action. In fact, my lord, these appellants have also taken an injunction order from the Honorable Trial Court, restraining him from, my lord, from lodging any further complaints. No cement used, my lord. No roof is also of not cement, my lord. Only a sheet and UPVC covering, my lord. And that too only the portion, my lord. In fact, the appellant number A has got a very huge balcony, my lord. Only a portion, 8 by 10, my lord. Even in the report it says 8 by 10 has been covered for the safety reason, my lord. Since that apartment is situated on the first floor, and this, my lord, consists of around 35 floors. To avoid the falling from the top floors, this covering has been used, my lord. In fact, my lord, the appellants are ready and willing to file an application to get it regularized under section 480 for 240 subsection my lord, 8, my lord, under BBMP Act. And they are ready to pay any penalty if so, my lord. If the BBMP finds that, my lord, any violation. I have photographs, my lord, to show that.
In your petition, you will not say that it is temporary.
I have, my lord. Even in the petition, even in the writ appeal, my lord.
In the petition, you will not.
I have said, my lord.
Not a single line. It is a temporary structure.
I'll read, my lord.
Show us.
Can I read, my lord?
Yes, it is there. Then show us.
I have mentioned, my lord. I'll read, my lord.
All the 11 appellants.
I have, my lord, I have mentioned, saying that it's temporary structure.
Where is it?
My lord, I'll mention, my lord. Just 2 minutes, my lord.
You are the only party, Mr.
Respondent number 1, my lord. BDA is respondent number 2 and 3.
BDA is party.
BDA is a party, 2 and 3.
Without hearing.
In fact, even in the reply, my lord, in the writ petition, my lord, we have mentioned, my lord, a reply was submitted.
While the order of learned single judge dated 10/3/25 sought to be challenged in this appeal. is an interim order, and in all ordinary circumstances, the court would not have entertained the appeal thereagainst. However, the order in question could be said to have the trapping of finality, inasmuch as it inter alia requires the removal of the interior directs the removal of the structure put up by the petitioners for the flat holders. Full stop. The case of the petitioner as submitted by learned advocate Mr. So-and-so. Case of the appellant petitioner as submitted by learned advocate the appellant petitioner is that learned advocate case as submitted by learned advocate for the appellant petitioner. The case is that the structures are only temporary in nature and are put up in order to cover the balconies of the flats. Full stop. Notice for final disposal. Returnable on 9th of April. Learned additional government advocate Mr. Harish accepts notice on behalf of this number 1. Whereas notice shall be served to the rest of the respondents. Full stop. Learned advocate of the petitioner is permitted to serve copy in advance to counsels appearing for respond 2 and 3. To the counsels for number 2 and respond 2 and 3 who normally appears in this court. Full stop.
One indulgence.
There shall be no removal of any structure in the flat of the petitioner till the next date.
Great.
On that they will dispose of. Full stop. As looking to the compass of the controversy indicated today, subject to the stand of the respondents, the appeal may be listed at 2/3.
Please move.
I appear for
Number
the
19?
to appear for the respondent, my lord.
6 days delay.
6 days delay is there.
Notice.
He is already appearing. Cavator is already there.
Only part.
Only part. It's an eviction suit, my lords. Commercial suit. It
The
happened, my lord.
apparent tenant is not paid the arrears of rent, my lord.
That I will pay it, my lord. I
Therefore,
understand.
I filed the objection on I number 2 or the stay, my lord. Week time may be granted. Week time may be granted on I number 2, my lord.
Execution is
Today we
already.
will condone the delay.
Yes.
IA 2 of 25. This application is filed by the applicant petitioner seeking condolence delay of 6 days. Full stop. Learned advocate Mr. So-and-so appears upon service of copy of the petition application in advance. Appears for the respondent. Only respondent
Only sole respond.
upon service of the application in advance. Full stop. From the accompanying affidavit. From the evidence in the accompanying affidavit, the delay of 6 days is explained. Sufficient cause is made out. Application is allowed by condemned.
There's an execution filed by my lord.
They will not.
Yes.
Since they are seeking time. We'll put up on, when shall we put up?
We posted in the first week of next month, my lord. That's the reason.
First
why.
week of next month.
Only ground for which it was rejected is written statement, along with the written statement of truth was not filed. That is the only reason why.
This is
the suit
expired on
was-
already 1 year. Almost.
1st of May.
Please. Great.
Appeal shall be listed on first. Commercial arbitration petition. Commercial appeal will be listed on first May. Only second May,
First of May is vacation.
holiday. No, second May is working.
Everybody's tuned to end of April vacations normally begin, so people are little bit of reorientation.
Number 20,
I appear for the appellant's
For
counsel.
the respondent.
But this arises out of a section 9 petition preferred by the respondent before the commercial court.
Lords, could
I am the
just,
landlord. I'm sorry, I'll just take a minute. I am the landlord. My
Starts, I
learned friend
want to know.
appears for the tenant. Your lordships noticed that there was no registered document, nor was it stamped, the lease document, and asked if they were running a school. Your lordships posed a question, my lord, to the other side to see if they'll vacate with the end of this, my lord, academic year, which is now. That is what they were to answer on the last.
Lords, I just want to make one submission. We have, as of now, already filed, if the court officer can keep, we have already filed a section 11, can you just give a copy? Section 11 petition for appointment of arbitrator. Yeah, just give one second.
That's all right. If
Just,
if
you
the
can
answer
take
to
the
the court's question is no,
One
then-
minute, 1 minute. This is against a section 9 relief that we have obtained. Thereafter, we sent them the notice for appointment of arbitrator. They replied, give me a copy, please. And thereafter, we have already filed section 11 petition for appointment of an arbitrator. Now, my lords, as per the Supreme Court's direct orders, even this honorable court, in fact, can appoint an arbitrator and expedite the, give a direction for expedited hearing. Once an arbitrator is appointed, whoever it is, in fact, they suggested a district judge. We suggested a retired high court judge. We are in my lord's hands. If an arbitrator is appointed and the arbitration is commenced, then in fact, the issue of whether the interim order that was given to me should be continued, vacated, modified, all of that will go before the arbitrator.
Section 7.
Section 17, exactly. Why are we delaying that? Ultimately, we are
Because there's a
claiming-
question posed by the court which you have not answered.
posed. The question may be posed. We are running a Montessori play school for which, in fact, this year is coming to an end. We've already commenced admissions for the coming academic year. And if any modification or vacating they want, let my lords may appoint the arbitrator today. We had in fact suggested.
No,
a
let me
retired-
then complete my submission. My learned friend's answer to
Certainly.
your lordship's
No,
question is
certainly.
no.
Yes.
Obviously, she's not saying no, but she means
No,
no.
I am saying no. I
Then
am
very well,
saying
then
no.
please say so.
I am saying
Then
no.
let me make my
Yes,
submission.
yes.
Lord,
I'm
here's the
saying no.
submission.
I am saying.
My first submission is this. Please be kind enough to look at the petition. My lord, that your lordships would get at page 107, the prayers are at 115. They are the tenant. They say they're running a school. Prayer is, but yes, my lord, please be kind enough to see that. Please come to. Yes. Now, my lord, what they would do is, yes. Effectively, they've been directed to be given possession by me.
We are in possession. In
Huh.
fact, no, I
The
just
court
want to
order, at the time of the court order, they were not in possession.
No.
After, 1 minute, please. This is what the order says. Please don't keep interrupting. After this, they forcibly
I'm
enter.
answering my
After
lord's
this, they
question.
forcibly enter.
No.
Now, my lord, they point fingers at me and do exactly the same thing.
We got the order to come back into possession. No, yes, this is acted upon. Now I'm back in possession. We were in fact vacated out forcibly after a lease was there. Thereafter, once we were thrown out, we filed a section 9 relief. Kindly see the operative portion of the section 9 order, which my lords is at page 63. Respondent is directed to open the locks and applicant shall take necessary steps from jurisdictional police to protect the applicant school from respondents or anybody. They were asked to reopen and put me back in. I am back there. Running the school.
My lord, I'll point out, my lord, 3 aspects for your lordship's kind consideration. First,
Yes.
Lord, please be kind enough to look at this lease document. Please come to page 67. It is unstamped, unregistered. I'll tell you lordships what. I was admittedly in possession. Now, according to them, I'm forcibly dispossessed. Learned commercial court would say, I've admitted that I forcibly dispossessed. I never admitted to this. According to me, they voluntarily gave over possession to me. But arbitrator is all right, but please see page 67. It's an unstamped document, unregistered. They don't pay revenue to the government. They don't pay me rent from October, and they want to go into arbitration. But what your lordships, my lord, asked was, Lord, I bowed down to your lordships. I bowed down. But what fell from your lordships last occasion was, all right, if this is your contract, you've not even paid rent, why don't you just vacate at the end of the year? We will not disturb till then.
Through
Yes.
arbitration.
No, not through arbitration, through the court, through settlement. This is nothing but unfairness.
1 minute, I just want to. If it could be sorted. Yes, but that is not.
In which case, my lord, may I seek this? They have not paid a single rupee towards rent from October. Let them make that good to show bona fides. They can't continue, my lord. No court would grant an injunction without them paying a single rupee. Let them make good all the rents and whatever other dues are there. And then, my lord, let their injunction continue. I'm not saying it can't be a situation where they don't pay, want to go into now arbitration to avoid your lordship's question, and then say, oh, I'm running a school, I'm running a school. Don't fire your gun with the children's shoulder.
Yes, in fact, our submission, my lords, is that the lease deed, in fact, commenced from April. Lease deed commenced from April. We were on 31/12, 31st December, we were locked out of the premises. Thereafter, we filed Section 9 application. We got the interim relief. And on 26th February, after 2 months, we were put back in possession. Now, my instructions are that all the rentals from up to March have been paid. And I think only now the month of April is not paid. We apart, 1 minute, in the only 2 months we are not paid is for the 2 months we were locked out.
Lord, let them show.
We have our instructions that apart from January, February, where we were locked out, we are due to pay all the rents, and we must pay. We have no difficulty in, of course, ensuring that we are due to pay rents, which apart from the 2 months of January and February, where we were locked out, till all other months, we are 100% bound to pay. In fact, we have a calculation. What I want to, in fact, show is that the rentals were actually 2,50,000. We have been paying 3 lakhs every month, saying they will pay GST. Then they don't pay GST, saying we are not covered. All those disputes have to be clarified before the arbitrator as to the exact calculation. Because in fact, one of the issues, no, my friend can.
This is
laugh,
essentially an admission that they don't pay.
No.
This is essentially an admission that they don't pay.
This is the rate of all the
This
payments
is, my
we
lord,
have made.
nothing but take
I'm
abuse of
sorry.
process.
My
They want to
friend
come
can
to court,
say-
get benefit, but not pay. They don't pay
No,
state
this is the
stamp.
list of the
Please see
payments
page
made by-
105. My notice in November says they're not paid in October itself.
No, this is
My
the
learned friend is
list.
going on giving documents without giving me a copy.
Yes,
Not,
just give them a copy. This is a list of all our payments made. In fact, we have been making payments of 3 lakhs.
Correct.
And the lease shows it is only 2,50,000. And the additional 50 was to be paid towards GST. Kindly see, my lord. So till March, all these adjustments are done.
No. I don't know
Kindly
how
see.
she's saying that till March there is payment. Second page
Apart
shows
from
October
two-
there is 0.
Apart from 2 months.
No,
Apart-
December there is 1 lakh. November is not shown at all.
No, it is adjusted, sir.
How is it adjusted?
yes, I will
Before you
show.
were
That
locked
is
out,
my
you are
calculation.
decided that you will be locked out, is it?
No, that is
I mean, I'm really quite puzzled by this contention.
My lords may just see. for the-
Admittedly, they've not paid.
May I please submit? My lords may just see page 64 of their petition, because I want to show my lords how the lease calculation was done. Kindly, my lords may see page 54. Page 54, 64, I'm sorry, my mistake. Page 64. This is the lease deed, and the operative, the rent is at page 85, my lords, page 85. Kindly see, my lords, page 85. My lords, we entered into a lease deed. This is the lease deed at page 64. After we were removed on 31st, first we filed we had a lease deed for 5 years. to run a children's Montessori school. Thereafter, my lords, in December, on 31st December, once we had started the school and the classes, they lock us out. They issue us a termination notice. While we are discussing and negotiating on the termination notice, they lock us out. After we are locked out, we file a Section 9 proceedings. In the Section 9 proceedings, my lords, we get an order on 10th February that they have to reopen and put us back in since we were running a school. Thereafter, after police intervention, only on 26th February, we were able to come back in. Now we are running the school and the children are there. These, in fact, we lost 2 months. All are on record. We have filed our objections. Yes, we have filed. Yes, we have filed both. Here we have filed. We have filed
Here,
our
ma'am,
objections.
it's here, it's filed.
So, in fact, in our objections, we have produced the photos. My lords may just see for a moment. May I? So now my submission is, let the arbitration commence. My lords may immediately appoint an arbitrator.
No, you have to pay. If you collect from them, you have to pay. No? Correct. They have to pay. You have to pay the demand. For these months.
My lords may immediately appoint an arbitrator with even to expedite. We have absolutely no difficulty. Any arbitrator of my lord's choice or any retired High Court judge.
Please, my lord, I have no difficulty with that. May I just make one submission? Please see my learned friend's memo. Admittedly, October, no month rents are paid. November, 1 lakh is paid. Please, that's all. As long as that is being taken care of.
Yes, yes.
We can do it right away, my lord. I have no difficulty
Lords
with that.
may I request, if my friend does not have any objection, my lords can appoint the arbitrator.
Very well, miss. I have no difficulty.
Yes, any,
Please, my lord,
we
we
had
will-
given, yes, we had suggested Justice Anand Bhaira Reddy. I leave it to my friend if he, that is suggested. Or
Please.
of
We'll
some
file a joint
retired
memo, my
High
lord.
Court judge.
Your lordship may give us about half an hour. We'll try and see if we can file a joint memo
Yes.
today. It'll also put it
Yes,
forward.
we can close it today. There is no difficulty.
They can't,
I'm
my
sure
lord, sit on.
some.
But your lordship may keep my contentions open because it's an unstamped, unregistered document.
All those
One
contentions
second,
can be
please.
there.
I'm not. All I'm saying is because even the appointment of an arbitrator can't be done, really speaking, in view of the 7-judge judgment if the document is completely unstamped. Without prejudice to that, your lordship will not appoint. I have no difficulty. That's all. That's all. That's all I'm saying. Of course.
Monday morning, yes, my lords, grateful. Yes,
Great.
great.
Yes, no, it's 2,50,000.
lakhs.
Plus there is
2.5.
a, my lord, increment from this month.
Rent
That's
is
what it
2.5 lakhs.
2.5 lakhs plus GST and other. I'm sorry, I'm told rent is 3 lakhs. I'll just verify.
No, no,
and
that
share
is
the document.
disputed.
That's
We
all
are
right.
saying it is
We'll place
2.5 lakhs.
It's all right, we'll
Yes,
place that, my lord, on.
yes, yes. Grateful.
Objections, we are
For 21,
filing one statement of objections, my lord, to the affidavit of BDA. We wanted to file a statement of objections, my lord, to the affidavit of BDA. We have it ready, my lord. Can we file it? Give him also a copy. This is BDA. You don't have a copy. Copy to the BDA. The issue here was, there is a very large project, which is a commercial and a residential project called Prestige Shantiniketan. Alongside, there's a road. The road which passes by. Now the question, is only not whose property it is. There is a relinquishment, of course, but does it automatically become a public road? That was the question really that your lordships were considering, my lord. That a mere relinquishment in the form of a relinquishment deed to the government or to a statutory authority, will it suddenly make the road a public road? That really was the question. And in addition, my lord, while my lord, there was some issue with respect to ingress and egress. No, I am on behalf of the residents.
I am for the developer.
My learned friend is with, and there are, my lord, about 10,000 people who live there, and they use that road for their daily commute.
It doesn't, my lord. In fact, it leads nowhere, my lord. That's all.
Lord, what happens is, from the main road, yes,
The
from
only purpose that,
Good.
the only purpose that road serves is for the residents of, my lord, this development. Because beyond that, there's a railway line. So there is no access that can be done. Anything beyond. Yes, beyond this development, there's a railway line. So therefore, my lord, it's not as if through this road, I can go to some other property.
and this
There's nothing-
road is being maintained by us. This, let the corporation not tell your lordship,
The
if they spend one single rupee on
commissioner
it.
may kindly be appointed, please, my lord. They say that there is a railway line, there is no extension of road, there is an extension of road. The order has been passed by. No, apart from that road, there is no road at all to access those properties. Therefore, I request your lordship, please,
We have properties there.
yes, representing public, please, my lord. Yes. No, that's not dead end, please, my lord. Therefore, I request your lordships appoint a commissioner, please, my lord. It is, I'll produce another judgment of this honorable court passed by your lordship only, confirming the order passed by the learned single judge about the extension of this road. Not only it comes to an end, it extends further.
Yes, but photographs were produced, my
There's
lord.
also a sketch, my lord.
The full sketch there. They are, my lord, residents of that area. They are not publics.
They're not residents there. They're in Girinagar, my lord, which is in South Bangalore. This property is in East Bangalore.
No, our properties are there, please, my lord.
But if their properties are there, then it can't be a public interest
Can't
petition.
be public.
If they say, my lord, there are two things they say. They say we are residing somewhere else. But they also say we have properties there. And they are saying we want to access our properties through this road. Then they call it a public interest litigation.
Can't be both.
You can't have it both ways. They are saying, my lord, not in the building. They are saying somewhere adjoining they have lands. It's a private list then. It for forcing, my lord, a litigation of this kind. Where is it?
No,
No.
it is on the extreme side.
It's on the side, my lord. It's on the side. It's on the side.
No,
of the
your
lot.
lordship may kindly, I may be permitted to take your lordship to ink page number 72, please, my lord, annexure E2. The developer himself has filed an affidavit that it is a public road. Now they cannot turn around and say that it is not a public road.
In law,
72,
it should be a
an
public.
affidavit has been filed. by the developers. Para number 4 may kindly be perused, please, my lord.
They own properties, they've said so. We allow them to use this road. We allow them to use the road. Petition, if they have property. They have property. They're saying so. Lord, that's a statement they made now in court. Yes. And we have also made an allegation, Lord, that it's only for their private use that this entire petition is filed. And my other friend, Lord, knows it.
No, your
Because
lordship,
he's
may
always
kindly-
there, Lord, in the property.
No, may I request your lordship to kindly peruse in page number 72, please, my lord, wherein they have clearly stated.
No,
We state that the said RCDP road is common to our development on the property and also any public who would like to use the same, including adjoining property worker. That is their affidavit. In page number 72. The very same developers, now they come and say that though it is relinquished in favor of BDA, though BDA is not objecting to the public to use the road, they say that they are objecting the road. Use of the road.
Lord, if
72 may kindly be perused, please, my lord.
if each of the petitioners will not have land there, and that's what they claim, then this will not becomes a litigation which is completely initiated with an ulterior purpose. It can't be, Lord, that they come in a public interest petition and file it, and my learned friend knows it because he's also there in the project.
That's also not the government in the writ petition, that they have lands nearby and they want to.
Oh, yeah, that is there, please, my lord. The villagers also, the impleading applicants are also there.
Lords, in my impleading applicant para 3 I have stated, my lords, I have
It is
access
being
to my
used
lands.
by the villagers, please, my lord, not only myself. My property is also there. The villagers are also there. The villagers are also impleading.
But that is not stated in the petition. Petition is made to sound like it's a public interest petition.
After relinquishing in favor of BDA, can they claim their private rights over the property? That is the question, please. my lord.
No one is
It is for the
denying.
BDA whether to allow the public or not. In fact, on 2nd June 2017, this honorable court has considered all the submissions and directed the police actually to see that, police and BDA,
Party
to
order.
see that the gates are removed
That was an
and the
ex parte order.
compound wall is removed. And accordingly, it was demolished in compliance of the direction of the honorable court, please. Your
That was
lordship,
a- that was
kindly
an ex-
peruse.
that was an ex parte order, my lord, without hearing anyone. And thereafter, my
They
lord,
were
this road was
served.
opened.
They were
And my
served.
learned friend can't take advantage of an ex parte order on
Sub-
this submission. when an order has been
Subsequently, an
passed.
application also came to be filed for modification of this order. That application also came to be rejected.
No, it was not rejected. Please. He said everything has been done, therefore the application does not survive. It was not rejected.
So may I read this order, please, my lord? 2726/2017.
Expiry order. Where- where? Three petition. Yes, ma'am.
No, there are five petitioners,
Five.
and also impleading applicants are there, please.
That is
They
now
are
they,
five.
after 7 years, some new people have come to make an impediment application, a pre-IL. I don't know how they can come. Let the first petitioners demonstrate that they have no private interest.
Lord, if my lord permits, my lord, on one of the compound wall, my learned friend's name is there.
That is, see, we
There's
don't
some
deny that, no, we don't deny that.
He
We
has a
don't have
property there.
properties there.
My learned friend has property there then.
No, not me.
How
Not
are they-
me. The petitioners have got the property. And we have stated also, please, my lord.
Can't be a litigation
No,
to save his
we have,
property.
we have stated in the petition itself. It's not that we have suppressed
No, no.
anything.
No, no, you're not.
Yes.
This is worse, my lord, than what we anticipated. That's all I
We have stated that, so we are
It's
also.
all for protection of that.
This is worse than what we anticipated.
That is there.
Sir, where? Where is it?
Staying is at Girinagar, please, my lord.
Where you stated that your property nearby?
Hmm.
Sorry, please, my lord.
Hmm?
It's not there.
Sorry, please.
But then you file. I will say that each of the five petitioners who originally filed this public interest petition shall state on oath that none of them have the property either owned or occupied to be accessed to through the disputed road.
On this road, please, my lord. On either side of this
For
road,
going to this road, you will not use.
please, my lord.
Accessing your property, which you are saying on oath that you do not have any property, either occupied or in possession or by virtue of ownership, to be accessed through the disputed road. Understood?
Or immediate family members, Lord. Often it may
All
be-
them.
No, no, your lordship may kindly say, we have to pass through this road to reach their properties, petitioners' properties.
Then say that we are passing this road. In course of the hearing, the court finds it appropriate to direct all the five petitioners.
I'll take instructions,
filed-
please.
Who filed, for our orders, you need not instruction. Who filed the petition originally shall file an affidavit, individual affidavit on oath, stating before the court that none of them have the property of any kind, either in occupation or in possession or by virtue of ownership, which is obligor to be accessed through the disputed road. Full stop. Such affidavit shall be filed on or before 8th. Put up on 8th. 8th of May. Ownership or any property in which they have interest in any other manner.
Yes, I'm grateful.
Like abutting to this road, please, my lord. Abutting to this road.
Now you read our order and understand.
Grateful.
Number 22.
May I please, Your Worship. This writ petition is a
This matter pertains to rescue of children who are involved in beggary and also that beggary cess.
The roads.
Yes. It's a
exploitation of the-
perpetual
exploitation
exercise,
of
my
the
lords.
baby
We keep
girls, ma'am.
rehabilitating, rescuing them, producing them before the Child Welfare Committee. Previous, 1 year back, my lords, 2 years back, earlier, my lords, there was a conference which was, this matter was held in the conference room, calling all the stakeholders. And my lords had recorded in detail that what are the effective steps being taken by the state and other authorities. Yeah, that's the latest.
Last occasion brought to my lord's notice that this matter was earlier held in the conference hall and requested that this also may be taken up in the conference hall. My lord agreed, but unfortunately it is not reflected in the court's order minutes. What? It was to be heard in the conference hall, this matter, because exploitation of baby girls, some delicate things were there. We felt it's difficult to explain in the court hall. The reports of the legal aid is there, legal aid committee is there. Yesterday I filed a synopsis also. 3 issues now remain in the writ petition. Pursuant to the orders of the court, though I had filed only in respect of 1 minute, the court enlarged the scope of the writ petition.
You are referring to meeting of the legal services authority.
Please, my lords.
It was
Your Honor,
convened.
I'm
It
appearing
was-
for the legal services.
It was
ma'am.
convened, my lord said, all the reports were placed before my lords. My lords were quite satisfied with the work of the state also. There's anything, if the learned petitioner points out which was
No,
not
there are
done, my
several
lords, we can
minute-
place on
Not
record.
1 minute,
Any
there are
specific
several minute. I'm ready
instance.
to argue. There are several issues that has not been answered. This itself, straight away I can take your lordship. This they have filed on 20th August 2024, this statement. The government has filed. One of the issues which the court pointed out is they collect what is known as beggary cess, the local boards. For example, I'm just giving an example. 10,000 rupees is the property tax. 10% is taken as the beggary cess. Out of 10%, 10% is retained by the corporation as administrative charges. 900 rupees to be paid to the Central Welfare Committee. What was noticed is the entire money is taken by them, not a pie was given to them. His Lordship Justice K.R. Singh, he pointed out that this is snatching the money of the beggars. That is totally unacceptable. Then the courts directed them to file a statement. Even in the statement, they admit that out of 1 crore 19 lakhs 91,077,105. This has been filed by them. That is collected as beggary cess. Amount to be paid is 63 lakhs 55,092. May I just pass on the court copy, the copy given to me, minutes. That's why the court directed them, in fact, my lord's order is there, passed on 12/2/2025, They have not replied that. Please also see the order dated 21/9/2023,
There is a beggary cess here.
My lords, beggary cess is collected by the urban local bodies and also.
The beggars.
No, my lords, in the transactions which happen, the properties which are registered and all those things, it's a beggary cess which is collected and that is deposited to the Child Welfare Committee, which in turn is used for rehabilitating these children.
That you must have
Yes.
scheme about.
Yes, there is a scheme and
That in the affidavit you
in the previous affidavits, everything has been mentioned. The only grievance was the petitioner is mentioning that these beggary cesses are not regularly deposited by these urban local bodies to CWCs. So my lords had directed last BBMP to verify whether the beggary cess has been paid up to date. That was the last order.
My requisition was confined to Bangalore minutes.
But BBMP, my lords, the BBMP.
My lords, for answer, my lords, as per the affidavit which is submitted on 3rd February 2024, we have paid the beggary cess to the Central Welfare Committee from 2008 to 2023-2024. My lords, the last year's update, we are yet verifying it, so.
file it, update, and then we'll put in.
May I submit minutes?
Some
Well, what has happened is, no, let
Just
me
give
clarify
measures
minutes.
Also file.
No, let me clarify minute. Now, I had filed the writ petition confining to the jurisdiction of Bangalore Miller. This honorable court Miller enlarged the scope for the entire state, pointing out that this involves not just of Bangalore, but an entire. This is the statement filed with the state Miller. Madam, I'm sorry, Miller, my copy itself I'm giving. So not only BBMP, even the state has to answer that. Please see the columns, Miller.
What is the steps you take if the beggary test cess is not paid?
Oh, my lords, we are still getting instructions.
You
on
be
that.
ready on that aspect. Because
Yes.
one of the aspect figures out in this proceedings about non-payment of beggary test cess, and therefore the sufficient fund is not utilized for the betterment of these beggars' child. So you have to update the court about the beggary cess collected by you, whether it is fully collected,
And
whether
what
it
is the money
effectively
due?
collected, how it is used, what are the schemes by you to use the amount of beggary cess. All those you just apply. If it is not on affidavit, on record, you place on record.
My lords will do.
Please.
In the meantime, you make suggestion.
No, Miller, what is it?
These
Miller, that's-
matters are not to be argued as such.
No, no, Miller, it's,
Not an
what-
adversary
Miller,
litigation.
Miller, that's what I said, Miller. Yesterday I filed this synopsis, Miller.
Ah,
It
it
is-
is there.
Yes,
We have
please
got
see,
that.
these are the three issues, Miller, that, and the last minute
We have seen that.
yes, action taken on persons forcing small children to illegal activities. Miller, what had happened was the
You don't have that
criminal cases are booked, Miller, that is not
project
pursued.
of teaching-
Juvenile justice.
project of teaching the children in the buses.
My lords, we have a standard operating procedure for care and protection of children in street situations issued by the NCPCRC. my
No,
lords.
don't you give education to
Yes,
children
CWC, please.
in buses?
Buses, yes.
Karnataka project was adopted in Gujarat. when
Yes,
Justice
yes,
Arvind Kumar was
that has been
that
placed
time.
before, my
We
lords,
were
in the
party to
previous.
that inauguration of
It's
that.
only on record.
It
Miller.
was based on Karnataka model.
Yes, please.
Yes.
We,
Children are taught is very good project.
Yes.
Gained very popularity and won the award of the
yes,
international,
yes,
I
please,
think UNESCO also.
I follow.
Miller, may just read one order of this honorable court minutes.
Street children are brought in a bus.
Yes,
They are treated for all purposes, food and clothing,
Yes.
and
please, my lords.
they are taught given the
Mobile
primary
schools.
in the buses.
Yes,
May I just read,
And the buses are stationed at the crossroads,
Please.
at the main parts of the
yes, please.
So that project is you are running or not?
Yes, it is still, wait, still valid.
You
Even
the-
that details will place on record. Next.
page 2 of the synopsis may kindly be seen, Miller. A reading of all the reports and the perusal of the data collected shocks the conscience of the court. From the reports placed on record, it is revealed that there are serious cases of child trafficking in the city, as it was revealed that there were allegations of sexual abuse of the children in the said institution. A case has been registered in crime number 21 of 2021 by Kachnagar Police, Ashok Nagar, state of Madhya Pradesh, containing allegation of interstate human trafficking against the said unregistered institute. The state government will
All
have to
these-
inform the court.
All these evils can be addressed provided you give education to children and take care of them. All these ills will be eliminated. So therefore, we want how you are using the vagary says, what are your schemes? What are the beneficial projects for the children? So give all those details and then you also give suggestion.
Please,
We put an end to their.
Please. We'll place it on record.
This comment, this, rest of the, will be.
that is given by the government means, that statement.
You give copy to this.
No, they have given me copy means. It's my copy that is now given to the court from them, received from them. I have received it on 20th August 2024.
So then it is evident that the amount is not spent.
And what happened is, again, they would have collected in the, for example, in the now, this year is a property tax that is collected by all the local bodies. This year again, they had to collect, give 10% to them. So what they do is, old balance they clear, and then they say we have cleared everything. But current, as on today, if they make a statement, that will give the correct picture. Every municipality is there. Panchayats, 5,000 something, they have covered. $5,949 local bodies.
One of the facet in this public interest petition is about taking care and concern by the authorities, by the local authorities, and all those under obligation, of the children of the beggars who beg on the roads, on the public roads of the city. The authorities, the local self-government, the authorities and the society at large is under obligation to ensure that the fundamental rights of these children in their various range flowing from Article 21 are not smothered or indirectly taken away. Full stop. For this purpose, paragraph. In order to bring these begging children to the mainstream of the society, the schemes for their upliftment, education and advancement are necessary to be chalked out and implemented. Full stop. In course of the hearing, it was submitted by learned advocate to the petitioner that there is a provision to collect beggar cess, beggary cess or
Beggary cess.
beggary cess, and the amount so collected will be utilized, is contemplated to be utilized for the various schemes and betterment, schemes of betterment of this class of children. Paragraph. In course of the hearing, a statement showing district-wise Beggar cess collected and remitted to the committee was produced, which is a copy certified by the Director, Integrated Development, Panchayat Raj Commissionerate, Bengaluru. Full stop. The details in the said statement taken on record are reproduced herein below in its herein below this entire you have to type. Full stop. The figures show that amount of rupees 1,19,91, 77,105 is the 3% Beggar cess collected in total by different gram panchayats in the different districts of the state. What is noticeable and discouraging is that the total cess remitted for central leave committee out of the said total amount is only rupees 56,35,84, 969. Whereas the remainder amount is shown to be yet to be remitted to the committee. Full stop. One thing becomes evident from the above figures, which is that the amount collected by way of Beggar cess is not fully spent for the relief and rehabilitation of the beggars and the children of the beggars. Full stop. A copy of the above details, copy of this order with above details, learned advocate for the respondent BBMP, Miss Pranjali, states at this stage that she will file an appropriate affidavit giving all the details of collection of the total tax, the spend, the manner and nature of spending thereof, and the schemes which are funded and operated by use of the amount collected towards beggary test. Such affidavit containing the above details and other relevant details will be filed on or before the next date, put upon 23rd of April.
My lords, June, my lords. June, my lords, may kindly take it up. Immediately after vacation, maybe second week in the vacation. Second week after vacation.
Similar affidavit containing the similar affidavit furnishing the similar details shall be filed by the state government in respect of the other cities and authorities outside the other in the city in respect of the cities and authorities other than the Bangalore, as the subject matter is extended to other parts of the state also. There are orders passed. No?
Please, Lord.
As per the orders passed by the court earlier.
May I request Madam, that the state can also give the present status of those criminal cases referred to by this honorable court. They themselves said they had taken some actions. What action they have finally, present status may have to be given.
Learned advocate, learned senior advocate, Mr. the petitioner, at this stage submitted that several criminal cases are filed.
Yes, ma'am.
Against?
Against the accused persons who are trafficking in with the children means.
Who exploited
Yes,
in
yes,
one or
numbers are
other way
mentioned.
the children of the beggars. To further submitted the details of such cases, the progress thereof, the status. And the progress and status thereof shall come on, deserves to be, is required to be, is required to be, is required to come on record. Full stop. The respondent shall also include such details in their affidavits to be filed as above. Send over to after.
After vacation, June 2nd week, some date may be given.
Any day after 3rd May, because any day after 3rd June, because I will not be there in the.
Tenth June.
Please, Your Lordship.
Great.
I pay for the petitioner.
23.
I pay for the petitioner. My lords.
I pay for respond number 1.
Pass over maybe.
So is not. It will go after 24th of June.
My lords, if convenient to my lords, April 25th, my lords.
Not possible.
Please, my lords, April 25th.
PIL, no time. PIL can't wait.
Password.
What is it? No password. What is it?
Lords, petitioners have sought for 2 reliefs against the state government, my lords.
Senior
It is
and
in the-
legs before another. And the password.
No, let us see what is it about. 21 matter. Why public interest should suffer for long years? So which do you proceed? Direct to existing. What is the procurement center? For what? Enable the farmers to sell the produce.
Yes.
Who are you?
Right Sena, my lords. Right Sena Karnataka. Petitioner here in my lord. I'm
We
seeking
don't
for
know his right Sena.
to opening of
Right
procurement.
Sena or wrong Sena?
Right Sena.
Right or wrong? So what is the subject matter? Let us see.
Pertaining to procurement centers being open for 365 days and also additional opening of additional permanent procurement centers, my lords.
What are the procurement centers?
For rice, my lords, MSP is
There is
provided.
no procurement. There is no procurement center in the state.
It is there, my lords.
And its figure is,
It
you
is
are not operating throughout the year.
Sorry, my lord.
You're operating these centers throughout the year or not?
It
When
won't
do
be-
you?
It won't be throughout the year, my lords.
So,
Lords, it will
there must be
during the
some season for some crop.
No, this is for only rice, my lords. Rice or some products wherein MSP is provided, my lords. And during that period, it is provided, my lords.
And in which, where?
Sorry, ma'am.
Period is provided where?
Lords, during
Is
the
there any rules or statute governing the?
Rabi period, my lords, when it is there. Rabi period, my lords. It is procured. In state of Karnataka, my lords, there is decentralization, my lords, wherein the state
No,
does.
Annexure C is the act
Please, my lords.
of 2014. In
Please,
this act, any provision about this procurement center?
Please, my lords. Annexure B, my lords, is annexure A for a moment.
So establishment, yes.
Annexure A, page 36 may be seen, my lords, for a moment.
Sir?
Apologies, my lord. Sorry, my lord, I was not there.
Take your time.
Yes, sir.
Before you, or we will grill the other side.
My lords,
Yes.
Page 36, if my lord sees. Last para over there, my lords. My lords, the system in Karnataka is, my lords, decentralized procurement system is followed, my lords.
It means that you will be also grilled.
Sorry, my lord. I'm just gasping my breath, sorry.
Yes. Page 36.
Page 36, my lords, of the
That was the
petition.
only suggestion while dealing with this matter. Isn't it? Yes, where is page 36?
36, my lords, if my lords is 36.
What
Lords,
is that?
last para, my lords, decentralized procurement system. My lords, this system is.
Now, actually, what do you want, Mr.?
My lord, this PIL is filed for twofold purposes, my lord.
Yes.
One is, my lords, to have the procurement centers opened on a 365-day basis. Two is, my lords, to also have increased the number of procurement centers.
So,
Today,
section 4 of the Act deals what?
my lords,
Section 4 of the Act deals with the
My lord,
establishment of procurement center.
yes, my lord, that would be prayer one would be to operate it on a 365-day basis. Two would be to set up additional procurement centers. Now, my lords, how the scheme works, my lords, is this. Karnataka is a decentralized state. Karnataka is a decentralized state, my lord, which works from grants from the union. Now, my lord, sufficient procurement centers need to be opened so that the crops grown in the Kharif and Rabi season are stored in the procurement centers. Now, my lords, the union has taken this specific stand that it is for the state to frame the policy in this regard. We only provide sufficient funding. The state says it is the union's responsibility. Now, my lords, we had come across one occasion where, insofar as Tamil Nadu is concerned, the Supreme Court was considering this issue and is still considering this issue, and it has been monitoring this aspect. The state specifically says, yes, we admit there is a change in the seasonal pattern. Therefore, they don't dispute that. Now, my lords, if the procurement centers are only open for 3 months a year, my lords, if the procurement centers are only open for 3 months a year, this is the problem that is happening. Many farmers, my lords, today are forced to sell their forced to sell their produce at a subsidized rate outside, thereby drastically impacting the prices, my lords. We are seeking for additional procurement centers to be opened. This would be in line with the Food Security Act also. My lords, I'll prepare a short note on this, my lords, because it is a slightly important issue, my lords. My lords, if my lords may only have it next week, my lords, if I may request, because it's an important issue, my lord. It directly affects them. And my lords, this issue is very identical to what is going on in Tamil Nadu, which is pending before the Supreme Court.
Then why should we?
My lords, so far as Tamil Nadu is concerned, my lords. Tamil Nadu is concerned. My lords, and there is no list per se between anybody today here. The only point which the center and state says this is a matter of policy, it is in our exclusive domain. We don't dispute it. It is a matter of policy. But today, my lords, are there adequate centers which are opened? Out of the total My lords, today we have about 5,958 gram panchayats in Karnataka. Now, whether each gram panchayat has access to a procurement center would be a question that would fall for my lordship's consideration. The second aspect would be, my lord, the center and state only have a MOU so far as custom milled rice. The other products, my lords, the other goods fall outside the MOU. Now, my lords, whether all these goods, there should be access to the minimum support price would be a question that would again fall for my lordship's consideration. Therefore, my lords, I'll just have a short note also prepared on this. My lords may kindly grant me a week's time on this, my lords. I'll any date next week. It's important, my lords. It affects the rights of many farmers, my lords. And state. Maybe copy of the act.
Respond number 1, my lords. Union of India, my lords. Please, my lords.
My lords, and I'm for respondent number 7. We are, my lords, I'm for respondent number 7. We are a non-contesting respondent, my lords. Respondent number 7, Karnataka State Warehouse Corporation. State Warehousing Corporation. We are a non-contesting respondent, my lords.
They would be necessary parties for the only reason, my lord, they would be part of one of the nodal agencies which implement the policies of the state.
My lords, in that respect, we have stopped, we are just a storage corporation.
My lords, what happens today, my lord, how procurement centers work is there are two agricultural seasons, the Kharif and Rabi. Generally, my lords, the Union of India, the central government states that during this time we would fix the MSP for 3 months during that season. So generally, my lords, the procurement centers are open for 3 months in each season. Yes, my lords.
My lords, I have filed my affidavit. Page 5, para 5 will be relevant, my lords, in
No
respect of
dispute on
first relief. Para 5, my lords, at page number 5, my lords. The
union
of the first respondent, my lords.
Yes, my lord, we have 5.
My lords, if I may only request my lords to have one para of the state's counter, that is para 12. On behalf of the state.
Yes, my lord.
My lords, could I request my lords to have para 12, my lords, in this, in their affidavit, my lords? Para 12, my lords. It is submitted that usually all major crops are seasonal and according to Government of India and respective state government implement MSP operations during the harvest. The procurement period is fixed for 3 months in each season by the Government of India. Due to change in the climatic conditions, etc., the traditional Rabi and Kharif seasons have itself undergone a considerable change. And if agricultural produce is available for sale throughout the year, then this should be a subject dealt with at suitable levels in the Government of India. Now, my lords, what the union says is, the union says it is for the state to decide. In this crossfire, my lords, the true sufferer is the person who is producing his agricultural produce, the farmer. He, my lords, is not able to access it. And the reason, my lords, they say is rather strange. They say if we keep it open 365 days, the produce would be given and middlemen will start exploiting it. My lords, quite to the contrary, the MSP would ensure, the minimum support price would ensure the middlemen are kept at bay.
My lord, the
My lords,
next
may see my-
sentence is important, my lord.
Yes, yes, I'll place
The
that.
next sentence in that paragraph, since the state government undertakes procurement as per the Government of India guidelines and change in MSP
Yes, I'm not
policy
disputing.
notified by Government of India will be implemented in the state. We are at the hands of the,
Support price.
yes.
Maximum price support. My lords, may kindly see annexure R1, my lords, along with the objections which I have filed. This is an MOU between the center and state government, my lords, page 10, my lords.
But my lords, that is only for rice, custom mill rice. My lords?
You want to file some pleadings?
No pleading, my lords. I'll give a written note in this, my lords, with all the relevant provisions and the support. I'll just place it on record by a note, my lords.
So when shall we give?
My lords, any date convenient to your lordships. My lords. Could I request for next week or any time, subject to your lordship's support?
24th,
25th?
25th, 25th.
Great.
But you have to show some statutory base.
My lords, it all comes under the NFS Act, my lords, Food Security Act. And my lords, in fact, the earlier Farmer Bills Acts, which were repealed, they dealt with these aspects. So I will place, though only for supporting my argument, my lords, though those acts were repealed, I will just demonstrate.
this matter may seek just a week or two's time to get instructions on whether anything survives in this petition, Manoj. I think in light of some subsequent developments, I'll just get instructions whether anything survives either next week or the week after next week.
Listed on 24th
Grateful.
at 2:30, since
Very well.
learned advocate is to take instructions
Yes, God bless you.
about as to whether the petition is required to be prosecuted or not. Yes. So that we remember, that's one. Yes.
25 addends, number 26, Shahbaz Hussain.
Right, here for the respondent.
Your Lordship, we are led by the learned advocate.
Appearing for the appellant, my lords.
Yes.
The order in challenge, my lords, is the order dated 8/8/2024, passed by the learned single judge, my lords. Can I request, my lords, to take page 25 for a moment, my lords?
Yes.
The operative portion is at page 27, my lords. The issue in question is, my lords, whether the writ petition, our preliminary objection is maintainability of the writ petition in view of section 126 of the Electricity Act, my lords. Writ is not maintainable, my lords. Here, my lords, what has happened is, the petitioner was paying tariff under HC2A, my lords. In fact, he has to come under HT2B. 2A is for industrial purpose, my lords. 2B is for commercial purpose. The nature of activity carried on by the petitioner herein is, my lords, no manufacturing, but for packaging of cement. We issued a notice, they have replied, my lords. They went to KARC, KARC did not entertain it, my lords. Pursuant to which a writ was sought to be filed. Our case is, my lord, in view of section 126, or impugned annexure A is order passed under 126, my lords. Appeal under 127 is there, my lords. Writ was not maintainable. The learned single judge failed to appreciate that fact, my lords, and passed the impugned order, my lords.
ಚಾನಲ್ ಇದು ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಇದೆ ನ್ಯೂಸ್ ಚಾನಲ್ಸ್ ಅಂತ ಹಾಕಿದ್ದೀನಿ ಸೆಪರೇಟ್ ಆಗಿ ಇಲ್ಲಿ
This 20 lakhs is towards what?
No, total of out of 1 crore 43 lakhs, my lord, the court has directed to deposit only 20 lakhs, my lord, before this honorable court.
No coercive steps, action against the petitioner.
Interim
notice is subject to the petitioner deposit.
We deposited.
Deposit.
We immediately deposited the money. That reflects, my lord, the so-called demand. As a matter of fact,
Mr. Advocate General, why you
My lord,
referred this?
the reason is short, my lord. Similar petition itself is not maintainable, my lords.
Then you raised that contention before learned single.
Objections.
Can I make one request to your lordship, if permitted, my lords? Can I make one?
Yes.
There are two. The court has said deposit 20 lakhs before this court. Kindly permit us to withdraw this amount, my lords, and let the maintainability be decided by the learned single judge at the earliest, my lords.
This 20 lakhs, my lord, reflects a claim for 2 years. Under section 52 of the Electricity Act, you can only make a claim up to 2 years. Nothing beyond that. They made a claim from 2008.
Pointed out. We'll argue that on merits before the single judge, my lords.
But let him make an application before the single judge.
No.
This can't be an appeal for asking for withdrawal.
No, not for withdrawal. The question is regarding maintainability of the writ petition itself in view of section 126.
Let them file their objections, we'll respond. 126 is not even the ground taken by them.
Which is a KSC order.
Order 149 annexure L.
Your Worship, can you see page 149 for a moment, my lords? At 281. 282 at 284, my lords. 284, my lords.
Page numbers are not there.
We've supplied a page number copy to my.
280. Please, my lord, that is the order of the APTEL, my lords. Your Lordship's got it, my lords, page 284. This was challenged before the APTEL. We, however, the second line, my lords, we, however, are of the view that the dispute pertaining to the bills is independent of the tariff determination exercise undertaken by the KRC and ought to have been subject to challenge in a separate legal proceedings. So, my lords, page 248, 240. I'm sorry, my lords, I'm not personally present.
Yes.
248 minutes. 284. Can you read, Manoj? We second line in 284. We are aware of the view that the dispute pertaining to the bills is independent of the tariff determination exercise undertaken by the KRC and ought to have been subject to challenge in a separate legal proceedings. Separate legal proceedings is under 126, order is under 127 of the Electricity Act. Writ was not maintainable at all, Manoj. Can I read short 126, Manoj?
That is assessment.
Assessment, Manoj.
The stand taken in the appeal is that it is under 42.5 and 42.6 of the Electricity Act. My learned friend now is saying 120.
And my learned friend has taken the contention that it is under 126. I'm going by assuming my learned friend's contention is correct under 120. Lordship may kindly see his objections, my lords. Paragraph number. I'll read 126 first. If on an inspection of any place or premises or after inspection of the equipment, gadgets, machines, device found connected or used after inspection of record maintained by any person, the assessing officer comes to the conclusion such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. So therefore the question was, Manoj, he was using, we have given HT2 connection for industrial purpose, which we have assessed, but actually he was using for commercial purpose, which is HT2B, which we have reassessed. Therefore, his appeal is under 127, Manoj. Section 127. Appeal to appellate authority. Any person aggrieved by a final order under section 126 may within 30 days of the said order prefer an appeal in such form, verified such manner, and may be accompanied by such fees as may be prescribed by the State Commission to the appellate authority as may be determined. He files an appeal to the APTEL against KSC order. APTEL says we will not entertain it. You go before the appropriate authority. Instead of doing that, Manoj, the writ is filed. And as your Lordship were pleased to point out, it's only an interim order, Manoj. So my scope of argument is very limited, which I should make honestly, Manoj, before the single judge rather than trouble your Lordship in that sense, Manoj.
But only most question is whether you should be permitted to withdraw.
Beg your pardon?
Whether they should be permitted to withdraw the. Are you disputing the entire amount?
Yes, my lord.
Assessment of it.
The entire amount is wrong. I'll tell you, Lordship, why. It is a factory. It has been classified as a factory. It has been used as an industry from 2003. And then, Lord, they make a demand for the first time from 2008 till 2024. Then, Lord, we go to the KERC and ask the KERC that you must classify it. If you think it is not correctly classified, classify it. KERC does not classify it. Therefore, we go to the APTEL. APTEL says the bill you can't challenge here. Therefore, challenge it separately. Therefore, we challenge it here. Bombay High Court has taken a view, Lord, when it's a question of classification, then the provisions of the Act with respect to an appeal does not apply and it has to be a writ. Therefore, we filed a writ petition before this court. And then, Lord, to show our bona fides, under section 52, they can ask for back claims only up to a period of 2 years. Therefore, we deposited the entire amount of difference between industry and commercial for 2 years, which is this 20 lakhs.
So we are going by the argument itself, we are entitled to that money undisputedly, going by my learned friend's argument, my lord.
I'm saying as a measure of an interim order, we deposited that money in court, not given it to my learned friend.
Not to me, my lord,
Which
to
is
my
why
client.
the court, after hearing us, it is a long order, court heard both sides and then said that we cannot go into this question, we'll examine all questions. You deposit the money which is at the very worst, the amount of money that they can claim. The entire money may not be deposited in court, which was the sum of 20 lakhs.
Not
And then
entire
we
sum.
file an appeal against that order.
Amount is 1 crore 40 lakhs, my lords.
For the last 2 years. Please see section 56(2).
Your lordship may kindly
Supreme
see.
Court has held that you can only make a claim for up to 2 years.
Incorrect, my lords. As per the provision, your lordship may kindly see section. From the date of assessment order, it is 3 years we have time, my lords. 2 years from the date of assessment, my lords.
56.
Section 56, my lords. Section 56, I may permit you to read, my lords. Disconnection of supply in default of payment, where any person neglects to pay any charge of electricity or any sum other than a charge for electricity due from his to a licensee or generator of the company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or a generating company, after giving not less than 15 days clear notice in writing to such person without prejudice to his rights, so and so, discharge or disconnect the electricity, and for that purpose disconnect the electricity so and so transmitted, provided the such supply shall not be cut if such person deposits under protest an amount equal to sum claimed by him, or the electricity charge due to him for each month calculated as the basic average of electricity paid by him preceding 6 months. So therefore, my lord, that is what my learned friend is saying, my lord. And clause sub clause 2, nothing withstanding contained in this in any law for the time being in force, no sum due for any consumer under this section shall be recovered after a period of 2 years from the date which the sum becomes due, unless such sum has been continuously as recovered as areas of charge excess supply shall not be cut off, my lord. This is where 2 years periods comes in, my lord.
Discovery of the mistake.
Date of discovery of the amount due.
That is in the judgment.
So go back 2 years. We've deposited the entire amount of money which reflects the claim for 2 years. Because there is no question of theft or anything of this kind. The agreement, and they have themselves admitted in a communication addressed to us that they made a mistake in classification according to them. And we've made payment of all sums of money in accordance with the bills right up to date. All of a sudden they come up and make a claim for 14 years and say you must pay the entire money for 14 years of difference.
My last submission, my lord. This is covered by the Supreme Court judgment, which my learned friend over there will hand over to you at page 32, my lords. This issue, my lords. Page 32, para 24. Hand it over. Who's there? Who's there? Page 32, para 24 of the judgment compilation, my lords. Can I read it, my lords? Can't see what the courts are doing.
He's giving it.
Given it. I can't see the court.
I'm asking you.
Can you see the court? Page 32, para 24, my lords. The matter can be examined by.
Amount is in court. Amount is
lying in the court, invested.
Beg your pardon?
Invested.
I think, is it invested? It can be invested in a fixed deposit. It benefits both parties. Let it remain invested. What is the order? Interim order. That is. no direction to deposit. I'm sorry, no direction to invest. It can be invested.
So, Mr. Advocate General, we can direct learn a single judge to dispose of the.
Can I make alternatively, at least let it be disposed of within next 1 month or 2 months, any, instead of deposit also, ultimately if the early disposal can be given.
We can request learn a single.
Please,
judge and
please,
further
that
deal
should be
with
more
it.
than sufficient. Please, that should be sufficient, my lords, because that should be sufficient, my lords, your lordship may kindly observe that, my lords.
So after recess.
I understand, your lordship.
After recess, we'll dictate the order, immediately after recess.
Please, my lords.
Hello. Am I audible?
Hello, ಹೇಳಿ sir.
Okay.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Is it audible from portal 1? ಯಾರು? ಬೇಕಾದ್ರೆ ಒಂದು ಕೊಟ್ಬಿಟ್ರಿ ಮೇಡಮ್, ಬ್ರೌನ್ಸ್ ಕೊಟ್ಟು ಸಪ್ರೇಟ್ ಆಗಿದ್ರೆ ಇವ್ರದ್ದು.
Hello. Hello.
Can you hear?
Yes, sir, I can hear you.
Okay. We can also hear you. So
Okay.
please keep it like this. And
Okay.
I will text you when the bench is here.
Thank you, sir. Good to finally see you.
Yeah.
Court officer, am I audible? Court Master, am I audible?
Court Master, can you hear me, please? I'm P. Chidambaram.
Yes, sir. Yes, sir.
I want to mention to the honorable judges.
Yes, sir. You are
Thank you.
audible, sir.
Thank you. Increase the volume.
Sir,
Serial number 43, we are withdrawing, my lord.
sir, regular bench. Says basic submission. Seal number 1, writ petition 32,197 of 19 for pronouncement of judgment.
No case is made out, petition is dismissed.
Seal number 2, writ petition 4635 of 2024.
So this is allowed in terms of the prayer. General directions are given to implement the provision. After writing long story.
Applied.
serial number 43. So we filing memo. This writ petition will become infructuous. So therefore we withdrawing, my lords. 43.
46. 43.
43, my lord.
PIL.
Yes.
What is the PIL?
Not this is to upgrade, my lord, the village up to a town municipal council, which we have said that because there is a stay in the, that matter is stayed in another writ petition, my lord, for the time being, we are not able to issue the final notification upgrading the village to a town municipal council. So they are seeking to withdraw that.
It will become infructuous, my lords.
4425 is submitted today by the honorable petitioner, which is taken on the record. Post of it read the memo reads the agenda. Record the memo. In view of what is stated in the memo, permission to withdraw, not in view, as requested in the memo, permission to withdraw the petition is granted. Learned additional government advocate Srimati Nilofer Akbar has no objection for petitioner, no objection to the petitioner withdrawing the petition. The petition is dismissed as withdrawn on the ground that it is infructuous as stated in the memo.
Lordship,
This is item 26, Your Lordship.
Number 26.
26 now. We'll pass the orders.
Grateful.
That is 20. We are not permitting the same order. 20 lakhs. 20 lakhs. We are not permitting to withdraw to them.
If the Lordships kindly
to
one.
invest it.
Grateful, Your Lordship.
Yes, and it will be open for you to request a single judge for expeditious disposal petition, and we as a court will record that. If such request is made, the court will look into it, depending upon the
Grateful, Your Lordship.
schedule of the.
Highly obliged.
We'll pass the order. How much is that? How many? Online.
Cell number 69.
Further steps have been taken, my lords. I have served a copy on the complainant also. On 27 March 2025, we have quantified the entitlement at 40,60,000. In another 2 weeks, the disbursement will be made. My lordships may kindly have it on 28th of this month.
28.
Very much.
29.
Please.
Number 70. Mr. Vasantappa.
Number 6, my lord. The previous date of hearing, I was directed to produce some document to show that whether there exists a road as per the plan or some documentary proof, my lord, the government. My lord, I'm producing a memo, my lord. Kindly permit me to file a memo, my lord. Is a
hello.
First document is the Deputy Commissioner's order, my lord, much before construction of my apartment.
Sir, can I have a copy? My office is.
What does it suggest?
Deputy Commissioner's order, my lord. In the very same order, my lord, the schedule wherein at the southern side, at page number 4, my lord, it's a original copy and translated copy. At page number 9, in schedule details, a southern portion says that stream, Halla and connectivity road. My lord. Subsequently, my lord, some old photographs have reduced to show that there was earlier, there was already a bridge constructed. And in the last document, my lord, this is the sanction plan, my lord. I have highlighted, my lord, wherein the two bridges, my lord, that is a Cambridge School Bridge, as well as the bridge connecting to my apartment is also shown, my lord.
Cambridge School Bridge.
Yes, that is one bridge, my lord, that is not disputed by the petitioner. However, the bridge in close proximity, that is my bridge, has been disputed.
Bridge is constructed with the height of 15 feet, my lord.
ಇದು Mohammed Moinullah. Mohammed Moinullah. Moinullah. MOIN. Respondent number 6, my lord.
Correct.
Number 71, Pritesh D'Souza.
Your Lordship, this PIL is with regard to the establishment of tree authorities in state of Karnataka, Your Lordships. On the last occasion, government has filed a memo stating that they need 5 months to enforce. As far as the request of the government to establish it is concerned, Your Lordships, there is no objections, but 5 months is too long, Your Lordships. Your Lordships, as far as the circular given, 7 districts they have already established. 7 districts they have already structured and established as per the circular given. It was not disclosed on the occasion when I filed an RTI, Your Lordships. It may be enforced throughout the state, but this is not the only concern, Your Lordship. In the representation, If your lordships, if I may guide your lordships to the representations filed by me, section 4 of the act, which is also cited by me in my representation, my relevant paragraph is at page number 46, your lordships. Annexure A, page number 46. Page number 46. 46 of my petition. Annexure A begins at 45. The paragraph that I'm referring to is at page number 46, paragraph number 2, your lordships, and unnumbered. I'm referring to section 4 of the act, your lordships. Annexure A begins at 45. My representation. Section 4 of the Karnataka Tree Preservation Act mandates meetings to be conducted, which is not being done. Also by the authorities which have been established, according to them, 7 have been established in 7 districts, not functioning, section 4. Section 6, there are certain, section 6 of the act, there are certain responsibilities and duties that have been bestowed upon tree authorities, your lordship. Even the 7 are not being functioned. This is also an appellate authority for tree orders, tree felling orders that will be potentially passed by all tree offices. Tree offices are subordinate to the tree authorities. So tree offices passing of these orders are appealable to tree authorities, your lordships. And these are also the responsible authority for counting the number of trees in the state of Karnataka and in their respective jurisdiction. So once they establish, they cannot wash off their duties, your lordships. These authorities may also function accordingly. So a direction to this effect may also be given to the respondents while granting a time for the enforcement of the established.
My lord, the representation, my lord, in that it's addressed to His Excellency the Governor also. No, my lord, the representation is addressed to His Excellency also. Annexure A. Yes. Page 45. 47. The first. No, my lord, I just wanted to bring to my lord's notice, lord, the representation is addressed to His Excellency also.
Your lordships, I'm not understanding why the citation is given to the excellency. I'm not understanding what the respondent is intending to
understand when it is the administrative duty of the state government.
As far as the representation is given, your lordships, it may not be considered as for the first person. The same is noted by this court on the last occasion, your lordships. The same has been noted by this court on the last occasion. Your lordships. This court has noted, yes, your lordships. Grateful, your lordships.
Number 73, Mr. Prashant Kumar D.
It's for the interim relief, it's a commercial appeal. May please. 73 and 74 almost relate to the same subject matter, my lords. It's the appellant before my lords and the first and second respondent started a partnership firm, my lords.
That we have also filed an appeal because we obtained another order against me
procedural in the sense in his order, there is a finding that I should not be disturbed. And in my order, there is a statement that we shall not be disturbed. But against that order, we have also filed an appeal. We give the number.
It's actually it's the same, my lords. If we argue this, that can be taken up. It's like this. It's a partnership firm. My lords, the property, scheduled property where the business is continued is my property. There is no dispute. It is not the asset of the firm. What is the business of the firm is it's a wedding venue, wedding and pre-wedding and studio, my lords, where it is. We are supposed to run the business. There is a dispute which has arisen amongst us. Two of them are one side, I am on one side. So I issue a notice under 43, I dissolve the firm. And I said no more thing. They go to the court under section 9. There is an arbitration clause, no doubt, in the partnership deed. But once under section 43, I issue a notice. It's a partnership at will. Once I issue a notice under 43, the firm's activities, my lords, are dissolved by virtue of the statute itself. Now, under section 9, they approach the commercial court seeking interim measure. The interim measure granted is I shall not interfere, and they will permit me also to carry on with the business. That, my lords, and the business of the firm. I file a section 9 application seeking injunction that they shall not interfere with the suit scheduled property, and the firm's activities shall not be carried on because there are bank accounts which they operate. And what's happening is this is a wedding venue, so they might also book venues. I will also book venues. So I said no one should. They also should not carry on any activities. If your lordship sees the order, the commercial court says it is a equitable thing. Let the business activities be continued. They will not interfere with my activity. I will not interfere with their activity, and rejects virtually my contention that the suit scheduled property is not a property of the firm. Now that is a settled position. Once there is a dissolution of partnership, business activities have to come to an end. If your lordship sees the order, my lords, in serial number 192, that's serial number 73 itself. The notice, that's 43.2 if your lordship sees of the Partnership Act for a moment. And that's, my lords? Yes, was issued by us. My lords? Once it is dissolved, it's only rendition of accounts that have to take place, my lords. That it stands dissolved. Once I issue a notice, my lords, 43.2. Section 43, if your lordship sees. Or the day he receives the notice. Once he receives, and that's the settled position where the Honorable Supreme Court in any number of judgments, my lords, I have the compilation, says the property firm stands dissolved moment 43 is issued. Now please see the order, my lords. Please come to the order. Yes, my lords. At 41, please come to 41 for a moment, my lords.
Yes.
Or 40, para 9. Sorry, 40, para 9, my lords.
Yes.
It is to be noted at this stage, this court does not find any reason to discard these documents to disbelieve them. As per section clause 13 of partnership deed dated 22/8/22 and clause 12 of the partnership deed dated 23/8/24, there are specific clauses that all disputes amongst partners shall be referred to arbitration. As such, dispute between the petitioners and respondent require adjudication by an arbitrator. Therefore, till such time the arbitrator is appointed and during the pendency of the petition, it is necessary to see that the affairs of the partnership firm is running smoothly. For this purpose, participation of the petitioner as provided in the partnership deed is very much necessary. Therefore, petitioners are entitled to some relief. However, it is pertinent to note that this court cannot restrain respondents from conducting the very business of the partnership firm in the suit scheduled property, nor this court can issue injunction from interfering with day-to-day activities of Kalanivasti and Destino. This court cannot issue ad interim injunction from operating bank accounts of the respondent 3, as these orders would adversely affect the development of partnership. And then the court says, no doubt petitioner has issued notice for dissolution of partnership firm, but at least for finalization of accounts, participation of. Now I seek an injunction against them. The court says, you are permitted to carry on. That, my lords, with great respect, the Honorable Supreme Court, my lords, I have this list of authorities. In 5 judgments at least says, once 43.2 is there, there is nothing more to be done. It stands, he can't carry on. So far as scheduled property, it's an admitted fact. It will,
Kindly see section 7, my lord. It is not a partnership at will at the stricto sensu. Kindly see section 7, my lord, of the act, where no provision is made by contract between the parties for the duration of their partnership or for the determination of their partnership. The partnership is at partnership at will. Section 7, my lord, is subject to contract. Basically, it's subject to contract. May I read section 7 again? Where no provision is made by contract between the partners for the duration of their partnership or for the determination of their partnership, the partnership is at partnership at will. Now, kindly see the understanding between the parties. The deed, I think,
my lord,
is
we have
not
prepared the
given.
deed
We
is
will
here.
give the deed. We'll give the deed. So that
Anyway, documents are ready. It is the same thing.
I will refer to the
Very well,
pagination
very
which
well.
I made.
If they want to, give it, let them give.
Is the only respondent?
He, yes, my lord, that is, he represents the two other partners, that's all.
But there are two partnership deeds. Earlier there were 4 partners. My contribution is 1 crore and 1 crore. His contribution is 25 lakhs, 25 lakhs. So totally, my lord, his contribution is 10%. Our contribution is of 40%. Lord, in that, my lord, can I draw your lordship's attention to page 29, the very first partnership deed. Very first partnership deed. In that, my lord, can I draw your lordship's attention to page 30? Just to show, my lord, the participation. I'll come to the actual clause later. Capital is 40%, 40%, that is the respondent, is 10%. Now, kindly see clause number 12 at page 33. This is relevant. This is referable to section 7. I'm sorry, page 34. Page 34, clause 14. The partnership shall be a partnership at will and may be dissolved by any partner by giving a previous notice of 3 calendar months. He has issued notice on 3rd of worst case scenario, issued the notice on 3rd of March. The date, commencement date will be 3rd of June. To the effect that all the parties, this notice shall indicate his or her intention to retire from the firm. The partner retires his share in the assets of the firm, and the profits of the firm from the date of his retirement is determined and becomes payable to him or her recoverable by him or others. Last sentence, it shall be necessary to execute the retirement deed lawfully. So this is not strictly a partnership at will. If he wants to retire, he can retire. I'll read 14 again. That partnership shall be a partnership at will and may be dissolved by any partner by giving a previous notice of 3 calendar months, which will expire in June, admittedly, to effect that to all the parties. This notice, kindly see the next sentence, this notice shall indicate his intention to retire from the firm. When partner retires his share in the assets of the firm and profits of the firm shall from the date of his retirement be determined and become payable to him or her recoverable from the last sentence. It shall be necessary to execute the retirement deed lawfully. So this is not, then my lord, the deed, partnership deed was reconstituted at page 37. Page 37, there is a change in the reconstitution deed. Page 41 may kindly listen, my lord. But earlier, under that, my lord, a working partner, a managing partner could have been designated. Now kindly see the change in page 41. Reconstituted partner after one of the partners retired.
Which page?
Page 41, my lord. That is the second.
Sir. 41. If it is there, you find out. No, you find out. Don't give. No. You find out. not to be given to them, the court papers. There is no page in my paper. So put your house in order.
Second,
Put your house in order. Any other respondent is there except them?
No,
Then proceed.
only them.
Then proceed, yes. Where is? 51 page is not available in our, either of.
Neither in my copy.
Ah.
I'm.
In fact, I have 2 pages missing.
So put your house in order.
May pass on my copy just for.
None of us have.
ಇಲ್ಲ 39.
How can all three we share from one?
Anyway,
We two can share. Put your house in order, come on 8th of. 8th.
Anyway, this I can explain. The second partnership also says that all of them are working partners. Both the parties shall be working partners.
What is that? You at least.
May pass. But I purposely apologize. ಇದಕ್ಕೆ ರಾತ್ರಿ ಎಲ್ಲ ಕೆಲಸ ಮಾಡಿದೀರಾ.
Sharing of profit, managing partner.
All of them are managing partners. Now, that is the change. Earlier partnership deed, they have to designate. Now, both the parties. Therefore, he is also managing partner and all the three of us are managing partner. Now, as on today, the notice issued by him was on 3rd of March 2025. The required period is June 2025. Therefore, the dissolution has not yet commenced yet. The Supreme Court says, my lord, it depends on the terms you see used in the partnership deed. If your lordship kindly see the earlier partition deed, it is not a partnership but will in stricter sense. So in the sense, it provides for dissolution of the partnership and retirement of any of the partner. Once he retires, 2 things happen. One is he has to issue 3 months notice. Second one is there shall be a deed of retirement duly registered between the parties. So these things have not taken place. Now, as on today, my lord, we have no objection. Ultimately, my lord, we are the brain behind it. He has given the land.
Partnership of will can be dissolved by any time.
Lords, see this. I'll just submit.
At the will of the either partner.
Lords?
Partnership at will.
It is a settled position. Please
There is
see
one
this
Supreme Court
judgment.
judgment.
I'll just take this. In fact, my lord,
There is
the
one
court
Supreme Court judgment that it is similar to co-partnership system. One of the persons, if he declares, from today I do not want to be part of the co-partnership system, it dissolves in the stricter sense, but notionally. But the Supreme Court says same analogy cannot be used in a partnership at will because rights are involved. Let us kindly see the intention. He wants the land. His contribution is 10% the land. We are the brain behind it. We have invested about 40% and 40% each. His contribution is 20%. The whole idea is to dissolve and take back the land along with the construction and all the infrastructure we have provided. Kindly see the conduct. We have invested, we are the brain behind it. Therefore, the court said till 17 kicks in, the interim measure under the Arbitration Act. Let there be equitable order that all the persons, we will give complete account for everything. Ultimately, we are running the show. We are the organizers. He has given the land. Now he wants to take back the land with all the infrastructure. So this is not fair according to me.
Lords, can I just point out the judgments, my lords? If your lordship please, our own copy.
Alva?
The first, sorry.
Only one you point out. The principle is well settled.
Yes, my lords, it's reiterated, but the first judgment I can show.
Only one.
The earliest judgment, my lords. The first judgment in this position is the first one, my lords, Banarasi Das and another versus Kanchiram, 1962. In that, please come to para 11, my lords. Para 11 starts at page 7, running page 7. But if your lordship kindly come to running page 8, my lords. Para 7 starts from running page 7, but relevant part would be at running page 8, second sentence onward. In a partnership at will, your lordship gets it. In a partnership at will, if one of the partners seeks its dissolution, what he wants is that the firm should be wound up, that he should be given his individual share in the assets of the firm, or maybe that he should be discharged from any liability with respect to the business of the firm, apart from what may be found to be due from him after taking the accounts, and that firm should no longer exist. He can call for the dissolution of the firm by giving a notice as provided in subsection 1 of section 43, that is without the intervention of the court. But if it does not choose to do so, that wants to go to the court for effecting the dissolution of the firm, he will no doubt be bound by the procedure laid down in order 20 rule 15 of the CPC, which reads under. Then, my lords, skipping that quotation of CPC, this rule makes the position clear, your lordship gets it. No doubt this rule is of a general application, that is to partnerships at will as well as those other than at will. But there are no limitations in this provision confining its operation only to partnerships other than those at will. Subsection 1 of section 43 of the Partnership Act does not say what will be the date from which the firm will be deemed to be dissolved. For ascertaining that, we have to go to subsection 2, which reads thus: the firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of communication of the notice. Now it will be clear that this provision contemplates the mentioning of a date from which the firm would stand dissolved. Mentioning of such a date would be entirely foreign to a plaintiff. Now, my lords, 13 also says that this very same position has been reiterated by Delhi High Court and all the other courts, my lords.
That without interrupting, para 11,
Let me just finish it.
Sorry.
Lords, para 11, then 12 and 13 goes into that. But if your lordship comes to the next judgment, the Delhi High Court judgment, my lords, which follows this at running page 11, your lordship should get 76 SCC online Delhi. There, my lords, please come to para 3. And then goes, my lords, I'm just taking your lordship's pointed things. I may mention it starts. I may mention that although the scope of suit was a very limited one, a very important question of law had arisen before the subordinate judge and the senior subordinate judge, which they have completely overlooked. The question was as to how a partnership can be dissolved. If it is a partnership at will, then section 43 of the Partnership Act applies. This section states that where a partnership is at will, the firm may be dissolved by any partner by giving a notice in writing to the other partners, and the firm is dissolved with effect from the date mentioned in the notice. Thus, if this partnership was a partnership at will, this firm would be dissolved by giving of notice by the present appeal. Such a notice was in fact given. Then, my lords, on law also they have held. I don't want to take your lordships. I can give the para numbers. Serial number 1 to 4 are all the same judgments which other courts have followed. The serial number 3, it is para 15 to 17, my lords, for the same principle. And serial number 4, that is Madras High Court, is from para 68 to 72. And notice having been given to them is admitted of dissolution, and the notice does not give 3 months time. Now, all that we are saying, they have bank accounts. Bank accounts are being run by them. We can't have somebody else running my business, or the court saying that let the partnership function could not even have been done so. There are 2 appeals. When they have been given the benefit, that is, my lord, serial number, the next one in commercial appeal 193, that's serial number 74. If your lordship sees, the court notices I have given a notice of dissolution, but still says in there I am permitted to function. That can't be the idea behind a dissolution of a partnership firm. All that we said is let there be an injunction. Not the worst case scenario. If the injunction is not there, since there is a breaking of trust, some receiver may be appointed, any neutral person, so that accounts are, because otherwise I am booking the venue, he is booking the venue, we don't know when there will be a clash. And in his case, he should have said. The dispute can be only rendition of accounts. course, that's the only saving clause for. I may also mention, my lord, the only saving clause for dissolution of a partnership to continue the partnership is found at, say, section 47 of the Partnership Act. That is to save transactions which had taken place or contracts entered prior to dissolution, section 47 of the Partnership Act.
How many partners are there? Two?
My lords, there are three partners. I am only one. They have two partners. The problem today, my lords, the dispute has arisen only because this one partner is getting cash inflow. We do not want cash transactions. My lords, the partnership was started to manage the business of this event. Unfortunately, what they have done, they have got into another contract with a third party. So there is a cash inflow. We know why the cash inflow is because one of the partners' husband is a senior sub-registrar. So it's only cash transactions that are taking place. We want to avoid that. Bank accounts operated by them. I have no control.
You are interested in running the business?
My lords?
You are interested in running the business in the.
My lords, I will run the business if I want. That's why, because
that is
now, my lords, if my learned friend says they have spent the money.
Dissolves.
No, that's my
No,
property.
that is the problem.
Property is mine. Okay, I will stop.
Once
I
it
can
is
also
dissolved,
stop.
nobody can run it. And I am 74% to partner and he's 26%. Now, that is the idea.
But the issue is this. The entire venue belongs to me. I had started the venue, they come in later. The partnership was for the management of the business.
Now, this is specialized operation of a event management.
I can finish
It is
and
not
if my learned
one
friend
more-
can
we are
start.
doing together, we are making clear. It's a event management kind of a thing, studio and all that there. It requires specialized skill, which we both of us possess. He's a landowner. His idea is throw out and run the business. We will undertake that, my lord, number two things. We entire 26% or even 100% will deposit before the court. Number two, we'll undertake that no cash transaction whatsoever.
Whatever we do, it is from
Pardon. My lords?
What is the status of appointment of arbitrator?
My lords, it is not yet known. None of us, we have only suggested in our notice with dissolution.
Notice is issued.
Issues.
Notice for appointment of arbitrator.
We have named the arbitrator also. We have named the arbitrator.
Justice Gururajan is named.
We have named a retired Honorable High Court Judge.
It can be up.
You are agreeable?
Yes, certainly.
So by consent, we can appoint the arbitrator.
Arbitrator can be, my lords, we have no issue on that at all, my lords. We have
To be candid, the loud thinking to be shared is that we are thinking that let the accounts be maintained till arbitrator is it. And
everything on standstill.
now, since you are appointing the arbitrator by consent, till the disputes are decided.
Only issue is, my lords, we have taken some bookings. My instructions are for marriage events. That's because I have the property now.
Therefore, we ask that you are also interested in running.
Yes.
All of you run together.
That's the
Account be maintained.
Now, second document says all are managing.
It will not to be construed adverse to your notice.
I understand, my lord's right.
Notice under section 43. This arrangement will not have any adverse influence on your
Or may I also suggest this? Any third party as a receiver.
No, it's
my
a
lords,
specialized, it's a
we have,
specialized operation.
because what
It's a
has happened,
specialized
we have, my
operation.
lords, I have no issues.
But it's not
because
some sort of a
we-
real estate.
There were police interference, so I don't want anything. Any retired judge,
The whole
any retired bureaucrat can be appointed as a receiver. I have no issue.
receiver for what purpose?
My lords, for managing the entire events, we will give, they will give
Specialized
that,
operation.
so that, my
And
lords,
he may maintain the accounts.
yes, my lords, because otherwise what's happening is if I go, police come in.
That is fair enough.
Yes, certainly. my lord.
So we'll pass the order.
Please, my lords.
Certainly.
Very well.
Run the
Your
show and
lordship,
account
ma'am.
can be managed. We'll give
Not
the
account. Everything will
Not
be
everything,
run
not
through him.
Tuesday we are keeping
Please, my
for
lords.
orders.
Please. my
Only for the purpose of accounting, we are agreeable.
Everything
Otherwise,
will-
it's a specialized operation where, my lord,
So
event.
you
This
come on Tuesday with agreed name of arbitrator.
Certainly.
So with your consent, we will appoint the
Please,
arbitrator
my lords.
to go into the all disputes. And till the arbitration is completed, this partnership will be run by
A rec-
a receiver
Yes, ma'am.
who will run on your behalf and maintain the account.
Please, my lords. Very well. Yes, we are agreed. That's, lords, that is, I am totally for it.
Accounting is concerned, he can supervise. The reason is this. The event management or studio and marriage, it cannot be run by receiver. We are the special, actually,
That's
three
it.
of us are specialized. Only
They
thing
can
is,
assist the receiver.
That is what we said, that you can participate.
Yes,
that's what,
of you.
yes, certainly.
All of you.
Through the receiver, my lords,
cannot-
they don't want somebody there.
For example,
Through the receiver.
for example,
Yes, my lord.
I'll give an example. Booking
Mr.
the,
Panindra is right that there must be a neutral person.
certainly. my
Take
lord.
up you are under in.
Because
dispute.
what's happening is, my lords, I
Requires,
will
for
book an
example, my
event,
lord,
he will book an event on
booking-
the same day. Then both of us, the problem will be for a wedding party. Lords, we will fight.
Lord, booking can be done by the neutral person, absolutely no problem. The reason is this, for example,
So
sophisticated.
what else the business is booking only? Any other business you are going to do? And they
No,
may
no, no, it require. Lord, I did not hear.
No, so therefore the receiver is the right way out. That's all.
Receiver certainly will supervise, he will also take the bookings, but the actual operation, for example, it requires hiring of sophisticated cameras. Cooking for providing the infrastructure on the particular day. These things cannot be given to the receiver. He will not accept it, number one.
But
Second one is.
suggestions, I don't know suggestions.
Will modality will.
Certainly, my
my
lord. It should be, my lord. A receiver cannot completely take over because it is impossible to run the show.
Will deliberate and work out modality.
Yes.
But you come with the agreed
Yes, certainly.
Arbitrator.
arbitrator.
But arbitrator, straight away, my lord, I agree.
What role the receiver is to play, what function is to will work out.
Please,
Yes, certainly, my lord.
Correct?
Tuesday, please.
Tuesday. Tuesday
I leave it to my lords.
at 11 we can take up.
Please.
11. Both. Both are same, Mr. Kumar.
74.
Both are same.
Sorry, both are same.
How two application? Two.
Lords, two is because in the first one, I had filed the section 9 application. Serial number 74, they had filed an section 9 and it's almost the same order is passed in that.
Our appeal, my lord, we shall give to the court martial.
It is almost the same. They want to challenge the order passed in my
Yes,
favor.
filed two appeals.
But
We have also
order
filed
in
two
one will
appeals.
take care of both.
It will, the entire thing will be solved.
All four can be disposed of, that's all I'm saying. All four can be disposed of.
Our order will take care of both the.
Yes,
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 yes.
Yes. Together will be posted.
Very.
Serial number 28. Shanti.
For the appellant's counsel. But there's one more serial number, my lord. I told you also there are 3 writ appeals. 2 are, my lord, listed in 28. Serial number 61, my lord, is the 3rd writ appeal. It's come up for the first time. If notice is completed and, my lord, a date is fixed, my lord, we can argue the matter in detail.
61 notice.
61, my lord, my learned friends may please take.
Will you accept? Notice written, heard learned senior court, Chand Kumar for the appellant, notice written never launched. When should it be after?
I leave it. till.
15th of June.
I'll ensure my lord copies, etc. Great.
Conduct.
I'm very grateful to my lord.
Both the appeals shall be listed together. 61 and this one. 9th June. Office offense shall be listed. 16 number before the next one.
Court officer 27 was not called out.
27 is not called.
7 was not.
27 urgent in morning, sir. 27 6.
Did you?
Well, we are the contesting parties here, none of us.
When it is kept? 3 days delay.
That was the one. On the last occasion, my lord had heard me substantially. It was a service matter, my lord. I am a physically handicapped person, and I was not, though I am eligible, I was not given the post.
Which is that?
27. We are the only parties who requested for an adjournment. Don't know.
Who?
Is there any other respondent?
Our tools also.
We are the two respondents.
Yes.
So I am the petitioner. These are the two respondents.
In my board, I have not noted that. Anyway, who mentioned?
While mentioning, somebody must have mentioned the serial number wrongly.
Maybe. My file is gone.
Oh, file is. Tuesday?
Tuesday.
Happens sometimes. No. Grateful.
But delay is to be condoned?
Yes, my lord. 3 days.
On that day we condone.
We'll see it on. Great.
Number 29.
Here for the appellant, Manoj. This
I
is
appear
a
for the respondent.
plaintiff's challenge to refusal to grant an ex parte order in a section 9 application. As I am the lessor in a property,
Today may not, we went to time.
As it's a short point. I appreciate, Manoj. It matters on Monday, if this could be kept on Monday. The lower court matters on Monday, Manoj.
I have one submission. It's an ex parte order that they have challenged. It's a section 9 application which is pending before the commercial court.
It's pending. For
Yes,
which
I have already filed my objections.
What is this order?
Plus the order refuses,
Ex parte order.
refuses to grant me an ex
I
parte
have
injunction.
appeared, I have filed my objection. It is for
I'll
final
just point out
argument on Monday.
one difficulty, Manoj,
No,
is
if
with,
it is pending.
yes.
then
My greatest difficulty today is that by this order, the trial court has said that this matter is not arbitrable without any justification, without reasoning, without explanation.
On merits.
Where is
There's-
the order? Let us see.
Lordship may take the impugned order, it is at page
Sir, we'll say
59.
that after this, when we decide a reference after hearing both the sides.
Manoj?
No, my respectful submission is that, my lords, the contract is determinable. And my lords, the latest judgment of the Supreme Court as well as the Delhi High Courts have held that, my lords,
It
the
is not
specific
determinable at his
specific
instance.
relief of the contract, my lords, is bar under 41 and 14 of the specific
It is
relief
not
act.
determinable at his instance, my lords. I can terminate.
You there.
That he can
My
argue
lords,
that.
exactly.
There is
Let
absolutely
all the
no
contentions be
justification to
kept
hold
open.
it is non-arbitrable. That's all I submit.
I have no
You
objection.
there.
Please, Manoj.
I have no objection.
Two prayers, my lords. One is that this finding that it is not an arbitrable dispute may be set aside because there is no justification for it. Because then the trial court, once they have held it is non-arbitrable, they cannot go into a section 9 at all. There is no justification for this finding. And two, your lordship may kindly direct that this matter be disposed of within 2 weeks. Because the problem is this, I just briefly say what the dispute is.
It can be
I
disposed
have
of on
taken a-
Monday.
I
It
have
can be
taken-
disposed of on Monday itself.
I
I'll
have
argue.
taken a premises on rent, which I have not been able to, sorry,
It is your application.
please, Manoj, yes.
Part rejected.
Yes, Manoj. Yes,
We
Manoj.
are saying that let it be heard afresh. He
I-
is agreeable.
Please,
In
please,
in view that he has filed a reply.
please,
Yes,
Manoj.
And all
And-
all contentions are open.
Please,
Yes,
this
my lord.
finding may kindly be set aside and a direction may be given for speedy
We are
disposal.
saying that it may be reconsidered.
Grateful,
heard
Manoj.
afresh.
Grateful.
Without being influenced by this.
Grateful, my lords.
Influenced, yes, my lord.
Please.
Yes,
And
absolutely.
the direction for speedy disposal is all I pray for, my lords.
Full stop. This is commercial arbitration petition.
It's a commercial appeal, my
Appeal.
lords.
Commercial appeal number 90 of 25. Having heard learned advocate Mr.
Pradeep Nayak, my lords.
Pradeep Nayak for the appellant and learned advocate Mr. Shirish Krishna for the respondent, and having considered the impugned order, comma, the undisputed position obtained is that the order dated, what is the date?
7/2/25.
10/3.
7th February, my lords.
7th February.
25, passed by learned 87th L XXX VII additional city civil and session judge in commercial arbitration application 87 of 25, which was an application under section 9 of the Arbitration and Conciliation Act 1996, comma, is an ex parte order whereby the prayer for grant of interim measure made by the petitioner appellant came to be rejected.
It was not rejected, my lord. Only notice was issued.
Notice is issued, my lords.
It was
The
not
ex parte
rejected.
prayer is
Rejected without granting, as no interim measure was granted, but only notice was issued.
Please, my lords.
Full stop. In course of the consideration of the appeal, it was given out to the court that in the main proceedings of section 9, the respondent herein has already filed its
Objections.
full stop. In other words, comma, the present order which is impugned before this court is and remains for all purposes an interim order. Full stop. The court below is yet to go into the merits of the prayer of the petitioner under section 9 in respect of section 9 application, which is pending to be heard after considering the objections of the other side. Full stop. It was stated, paragraph, that the proceedings before the court below are slated to be listed
On 7th.
on 7th of April. In the aforesaid view, without going into any aspect of merit of the impugned order, as well as the contentions raised in this appeal, comma, the court considers it appropriate to adopt a course to direct the learned 87th additional city civil session judge into bracket exclusive dedicated commercial court bracket over Bengaluru to decide the proceedings of section 9 application after hearing both the sides and giving opportunity to them to raise their contentions. The exercise may be preferably done within 1 month.
1 week, my lords.
No.
The pleadings are complete. It's only a section 9. It's an interim application. 2 weeks, my lords. Because 2 weeks, my lords.
The court will be shut for vacation.
Preferably within 3 weeks.
Please, my lords. Grateful.
Therefore, there are all holidays.
And the vacation
Three
starts.
3 weeks would be, I appreciate, my lords. 10 to
Preferably
14th are holidays.
On or before 30th April.
Deeply grateful.
It is observed that the decision shall be rendered in the section 9 application by the court below. Without being influenced by the observations in this order, independently and on its own merits.
Grateful.
In which all contentions available in law to both the sides shall be open to be raised.
Grateful.
Grateful.
I am grateful.
Will be permitted to be raised. are permitted to, permitted to be raised. All pending applications, all pending interim applications, then dispose of, any of the disposal main appeal. Yes.
Serial number 33, my lordships. They are creating a layout in forest buffer zone. A date may be fixed. Serial number 33.
33.
33, my lordships.
It's a PIL.
PIL matter, my lordships. A date may be fixed. They are creating a layout in forest buffer zone.
9.
48, my serial number 48, my with regard to dispute of allotment of land, my lord.
Serial number.
8 May 15th or 16th, my lord.
Take chance on 16th.
16th.
Your lordship.
Serial number 38.
We'll see, we'll see.
Serial number 38, my lord, is regarding release of pensionary benefits to the.
Serial number?
Serial number 38, my lord.
13.
38.
33.
38, my lord.
38.
In this matter, my lord, I appear for the respondent.
Respondent.
So when do you want?
The order has been complied. He wants now the retirement, the order passed by the learned single judge, my lord, the leave salary is to be paid. The complete 8,60,000 has been paid. My learned friend now is asking for the
As per the
pension.
representation, they have to consider
Let them
the
consider.
pensionary, release the pensionary benefits, my lord.
But he says that it's complied with.
I will submit. for
As
lordship's
regarding
minutes.
pension,
Then
my
we have
lord,
this
it is-
matter
that is not a part of the order. my
Oh,
lord.
like 22nd.
on 17th minute.
17th, who will come? Except myself and yourself.
Lordship.
Serial number
Serial-
60. My lord,
Date minute.
22nd.
serial numbers.
Yes.
Your lordship, serial number 49, your lordship. There's an interim order in this, your lordship, that has to be extended.
Entry mode. Wherever entry
My
mode
lordship,
is there.
serial number 60, kindly have it on Monday. Serial number 60, my lord.
16.
Is 60, my lord. 60, have it on Monday, my lord.
What is that?
The matters pertaining to that smart meters, my lordship. That without tender notification, that third respondent has awarded the contract in favor of some XYZ. So have it on Monday, my lord. That is 7,500 scam, my lordship.
Monday 20.
My lord, serial number,
Serial number 32.
Monday or Tuesday, my lordship. There is some urgency.
Say then 22nd.
My lordship.
22nd.
21st. 22nd. It's a big scam, my lordship. That it is a big scam.
Big scam, so then 23rd.
Have it on Tuesday or Wednesday, my lordship. Wednesday.
Not possible. So many matters.
Wednesday.
Till not reach, and again you will mention, and then I'll give again the date.
What has
beyond
happened that without following the KRC regulations,
But same thing will happen on the next day. If we keep it on this Monday, we will mention at 4:45, and I'll give the date of 23rd June.
almost this matter listed almost more than twice, my lordship. Have it on Wednesday, my lordship. Because
21st.
it's a too delay, my lordship. Have it on Wednesday or Thursday, my lordship.
It will not be possible.
Serial number 32.
7th.
my lord.
Serial number 32, my lord. Serial number 32. Any day after 20th, ma'am.
Any date? 24th.
Oh, oblige, ma'am.
Serial number 46, my lords. My lords, I'm appearing online, my lord.
7.
Yes.
My lord, serial number 46.1 and 46.2 has been tagged with 46 incorrectly, my lord, and I had made this submission on the last date of hearing. However, the registry has not done the needful
What
to
is it?
delink.
46 is a group of matters. What is it?
My lord, that's
What is
a my lord, mine is a writ appeal that arises from, it's a private party litigation that arises from the order of a deputy commissioner mutating orders, entries in favor of the petitioners, my lord. But serial number 46 is to do with, is a KIDB group matter, my lord.
So we want to. This is. No, what is 46? So you want to delink 46.1 and 2?
Yes, my lords.
On that day we'll deal after seeing the subject.
My lordship, the one
Yes.
request on 17, sir, kindly have it at about 2:30, my lordship. Like,
On 17, there is no 2:30.
No, that,
30 is not.
no, date has been given by this court, my lordship.
On that day, 2:30 will not come. Only up to first half. Then what?
18, my lordship.
18.
2:30.
Special board to be prepared.
18th was a